A very good evening to all of you. Today, myself, SHREYA SAHNI, would like to present a topic in front of you that is the custodial death and fake encounters when saviors of a country, that is the policemen, becomes the slayers of the country. So, the Constitution of India guarantees various rights to a prisoner or a person in custody under Article 20, 21, and 22 of the Constitution. The Honorable Supreme Court of India has interpreted certain rights such as right against inhuman treatment by the police, right against handcuffing, right to a fair and a speedy trial, and right to free legal aid to be an integral part of Article 21 of the Constitution. But when a suspect dies in the police custody, it conveys a disgrace to our constitution. That is one of the best constitutions of the world. Such incident raises serious questions about the violations of the rights of the victims, the responsibility of the state to curb such offense, and the need for enactment for suitable legislation. So, coming to the topic that what is custodial death? Custodial death is defined as the death of a person due to any form of torture, cruel, or inhuman or degrading treatment by the police officer, whether it occurs during investigation, interrogation, or otherwise. It is perhaps one of the worst crimes in a civilized society governed by the rule of law. The Honorable Supreme Court has held the prisoners are entitled to fundamental rights while they are in custody. If you look at the custody in the context of the arrest, it does not imply the usage of any kind of violence just because the one in custody is an accused. Thus, that should be duly acknowledged that the person in custody or a prisoner can't, can't never be deprived of the basic human rights except those which are curbed by the Honorable Court. A police officer has the power to arrest any person to investigate the case further, but has no power to use unnecessary force to extract the information from that person. Also, the power given to the police officer is discretionary as the word may is used in section 46 of the CRPC. So, it is the duty to arrest a person according to the facts and circumstances of the case and not otherwise. Fake encounters. Coming to what are fake encounters, it is defined as the extrajudicial killing of the persons who are usually in custody by the policemen without following the rule of law. It is staged in such a way that it appears to be a crossfire by the policemen. Encounters have not been into India, but in many cases, the act of police prima facie appears to be suspicious. As per the RTI request filed with NHRC, it came into light that in between 2000 to 2017, 1,782 cases of the fake encounters were registered in India, out of which the state of Uttar Pradesh made 794, that is approx 44%, 44.55% of the total. Since 2017, a new government took charge in the state of Uttar Pradesh, and the number of encounters has been a great surge. Now, increasing the scope of the private defense by saviors of our nation, a police claim of self-defense is to justify encounter claimants must be held to higher standards of proof as the force is armed and trained for combat. The encounter deaths of five persons suspected of having carried out two bank robberies in Chennai is reminiscent of the Batla House encounter. It has once again focused the attention on the practice of extrajudicial killings in Tamil Nadu. Reports in the Hindu indicated the police got a tip off about where the perpetrators were, but after the photograph of one suspect appeared in the media. As a follow up, the official version goes the policemen visited the premises where the five men were and asked them to surrender. They in turn fired on the police, which resulted in the five being shot dead. Such a construction possesses many uncomfortable questions. That how was the man in the photograph identified as one of the men in the house? Again, why did the policemen did not wait to surrender them? At the time of the firing, there was nothing to indicate that those were killed involved in the heist. They were purported to have been identified by eyewitnesses after they were killed. So the official claim that the police had to exercise their right of self-defense as they were shot at raises more questions than answer. It sweeps under the carpet, disturbing the aspect about the modus operandi of the police in instances when they seem to conduct themselves more like a vigilante group rather than a protectors of the law. So in all the cases of encounter deaths, the practice is to claim that the killings were done in self-defense. So under the penal code, that is the IPC, the right of the private defense is available to all, but no distinction is made between the police and the layman. So however, taking the away of the life can be done only under exceptional circumstances. So the person seeking the right of private defense must have a reasonable apprehension that the person who is killed, who have killed him or her or caused grievances, could attempt rape, kidnapping, or abduction. So, leading case in India regarding the fake encounters and the very profound case in 2020 was the Vikas Dubey encounter case. So, this incident took place early morning of July 10, 2020, where a hardcore criminal accused in recent murder of 8 policemen in Kanpur on July 2nd, 2020 was being taken away to Kanpur from a jail by Uttar Pradesh Special Task Force on the way to Kanpur. A vehicle carrying the accused is said to have been met with an accident, wherein the accused tried to flee away from snatching the pistol of the policeman. It is further said that the policeman surrounded him from all the sides and requested him to surrender, but he fired. In counterattack, the policeman also fired, in which the accused got injured. After being taken to the hospital, he was declared dead. So the vehicle of media houses who were following the vehicle in which the accused was carried was stopped at a little distance away from the place where the said encounter took place by a large police force. A search was conducted of all the vehicles, and as soon as one of the vehicles of the media house was allowed to go ahead, they found the vehicle carrying the accused to have met with an accident and an encounter have taken place. So a similar incident happened with the vehicle carrying one of his aides on July 9, 2020. A vehicle carrying him got punctured, and is alleged the accused tried to run away from snatching the pistol of one policeman, and he was killed in the crossfire. There was also a case of Ram Narayan Gupta case in 2006, where Mr. Ram Narayan Gupta was picked up from Vashi and was killed in alleged stage encounter at Versova. Later in 2013, Mumbai Session Court sentenced 21 people, including 13 policemen, for killing Ram Narayan Gupta. So there is an alarming data of the custodial death in India. That is, there were on an average of 5 custodial deaths per day in India in 1st April 2017 to 28 February 2018. As per the report of the NCRB, the number of deaths in the police custody between 2001 and 2018 was 1,727, but only 810 cases were reported. 334 were charge sheeted, out of which 26 policemen were only convicted. It is especially mentioned in the report of the NCRB that in 2017, 58 custodial deaths were of those who were not even presented before the court of law. Reported by Asian Center of Human Rights, ACHR, stated that the state of the deaths in judicial as well as the police custody, there were 1,530 deaths in the former and 144 deaths in the latter during 1st April 2017 to 28 February 2018. National Campaign Against Torture released a report stating the data of custodial death in 2019, which affirmed that out of 125 deaths, 93 deaths, that is 3 out of 4, were due to torture or foul play by the police. So there are various rights of a person in custody or a prisoner under the Article 21 of the Constitution, which includes right to bail, right to free legal aid, right against handcuffing, right against solitary confinement, right against inhuman treatment by police, right to a speedy trial, right to a fair trial, and right to detain you to socialize and to have an interview with the lawyer. So there are various legislation pertaining to the offense of the custodial death in India. That is the IPC under section 302 for the offense of the murder. Then the police officer can be punished for custodial death under section 304 of the IPC, that is culpable homicide not amounting to murder. Though the provisions of section 304A of the IPC, that is causing death by negligence, can also be attracted if the case falls within its ambit, and if the victim has committed suicide, then it is proved that the police officer has abated the commission of such suicide, and then the police officer will be liable for the punishment under section 306 of the IPC. So punishment for custodial death, custodial violence under IPC: when a police officer voluntarily causes death or grievous hurt to extort confession, then such a police officer shall be punished under section 330, that is 330 of the IPC, causing voluntary hurt, then 331 of the IPC, causing grievous hurt, that is voluntary again. A police officer can also be punished under section 342 of the IPC for wrongful confinement. So there are various provisions under the CRPC 1973. Under section 176 clause 1 of the CRPC, the magistrate who is empowered to hold inquest with respect to an unnatural death may hold an inquiry into the cause of the death in addition to the investigation held by the police. There is also section 176 1 clause A. Then the magistrate holding an inquiry or investigation under section 176 1A of the CRPC shall within 24 hours of the death of a person forward the body of examination to the nearest civil surgeon. Then laws relating to fake encounters, that is Article 6, Clause 1 of the International Covenant of Civil and Political Rights, that is ICCPR, that every human being has an inherent right to life and the right shall be protected by law. No one shall be arbitrarily deprived of this right. Then the staged and the fake encounters referred to at an instant justice by masses are against the key constitutional provisions, that is Article 14 and 21 of the Indian Constitution. Then section 96 and 100 from the IPC provided with right to private defense. As per 96, no offense is made out if any act is done in private defense, that is the self defense, but it needs to pass a test of section 99 of the IPC, which provides the act should not be extended to causing more harm than it is required for the purpose of the self defense. And section 100 provides that self defense extend to causing death. For an act to fall under the self defense, certain conditions need to be satisfied. That is, the accused should be innocent while committing the act. There should be absence of any safe and reasonable mode of escaping by retreat. There must be apprehension of death and severely body injury, and there should be necessity of taking the life. Then clause 3 of the section 300 of the IPC, then section 46 clause 2 of the CRPC provides wider power to the person making arrest. It provides that if any person tries to escape arrest, the person making the arrest has power to use all the necessary force required for the arrest. There was a case of the DK Basu versus uh, DK Basu versus state of West Bengal. Here, the Supreme Court held and gave certain guidelines which must be followed by the police officer while investigating the case. It is the duty of the police officer to arrest the person and handle the interrogation in an accurate and fair manner according to the provisions of the code. The police officer must also prepare a memo of the arrest and must abide by all the procedures. Also, person who is in custody of the police has the right to have one family member or friend at the time of the arrest, and duty of an officer to give the place and time of the arrest of an accused. The information to the family member or the friend must be notified within 8 to 12 hours of the arrest, and the diary should be maintained by the officer who disclose the date and time of the arrest and other required of information to family and members. So concluding, the study concludes that the misconduct of the police during an investigation is increasing in India day by day. So it is necessary and permitted by law to interrogate an accused person, but at the same time, it is also provided that the police have no right to take the law into their hands and no illegal method should be adopted to investigate in the case. To confirm with the constitutional provisions and human rights aspect, it is necessary that these offenses against the arrestee must be curbed in a democratic country. So here are my few suggestions, that there should be incorporation of new provisions that specifically deal with the issue of the atrocities of the police officials, especially for the custodial death, as it has been suggested by Law Commission report as well. And the 3Ps paradigm should be adopted to combat these offenses, which include prosecute, prevent, and protect. So the prosecution refers to effective law enforcement action taken in order to eliminate crime. Rigorous punishment should be awarded to such criminals for violating and taking away the people's fundamental rights. Then the principle of vicarious liability must be applied to the state. As a result, as the direct result for the commission of the crime of the custodial death, and the police authorities must be held accountable and responsible for the failure on this part to prevent natural death of an accused in the lockup. The state must possess the attitude of zero tolerance towards the perpetrators of the crime and incorporate such laws which give strict penalty to the perpetrators of the crime. And effective judicial system is not the root cause of the good governance and peaceful society. Thank you.